Good evening, everybody. Yeah, today's lecture, we are covering the BNS, how it functions in the court of law, not from the how it is stated in the test books. Okay, first you know that here, by virtue of the provisions of Article 242 of the Constitution, which you will find in the concurrent list, entry number 2, CRPC can be legislated by both the central government as well as the state government. Now, in my last lecture, we discussed the we discussed we discussed the provision relating to constitution of the criminal code. Unlike the Code of Civil Procedure Code, which does not define courts, fortunately, the CRPC, the BNSS, defines criminal courts, which you will find in section 6 of the BNSS, like 2023, which was earlier section 6 to 13 of the CRPC. Now it is section 6 to 11. Now the courts which are constituted for conducting criminal trials are number 1, apart from the High Court, the Court of Sessions. Number 2, judicial magistrate first class, judicial magistrate second class, and the executive magistrates. So this you will find in section 6 to 13 of the BNSS, and earlier section 6 to 11 of the CRPC. Now the CRPC sections I would like to give it to you because the provisions of BNSS clearly mandate that whatever litigation which has been pending prior to 2023 will be conducted as per the provisions of the CRPC and application of the Evidence Act. So most of the cases you will find old cases which are going on for the last several years. A criminal trial cannot be concluded in the city of Bombay in India at least for 15 to 20 years. So you should know the provisions, the parallel provisions of both CRPC as well as BNS. So I will make an attempt to give you both the provisions. So you will find the provisions with relating to constitution of the court, section 6 to 13. Please make a note of it, which is equivalent to section 6 to 11 of the CRPC. So again, I won't repeat at the same time. Then I also brought to your notice, attention, that what are the powers of these courts? What are the powers of these criminal courts? Now these are given, the powers of the courts are given in section 21 to 23 of the Act, BNSS, which are equivalent to section 26 to 29 of the CRPC. Please note that. Now, as I mentioned, I brought to your attention that the High Court and the Court of Sessions can award any sentence up to death imprisonment, death sentence. But the death sentence given by the Court of Sessions is subject to confirmation by the High Court. The confirmation powers are given by the High Court under section 407 BNSS. Please note that, which is equivalent to section 366 of the CRPC. Confirmation of death sentence can only take place subject to the sanction from the High Court. Otherwise, no. Now, we learned that here, then the Court of Magistrate, the Court of Magistrates, especially judicial magistrates, can award punishment up to 7 years only, though they can try offenses up to punishment which can be awarded up to 10 years, life imprisonment. But maximum punishment which can be awarded is up to 7 years. This is section 23 of the Act. Then the Court of the Magistrate of the first class can award sentence only up to the period of 3 years and a fine of 50,000. Please note that. And whereas the Court of the Magistrate second class cannot award imprisonment for more than a period of 1 year. 1 year and a fine up to not exceeding 10,000 rupees. Apart from this, this magistrate can also award community service, which has been introduced recently in the year 2023 by virtue of explanation to section 23. Please make a note of it, BNSS. These are the uh, powers of the criminal courts. But these courts, in the code of civil procedure code, we have mentioned that these courts are not explained, except a district court has been mentioned under section 2(4). Then you have to go back to the provisions of the Bombay Civil Courts Act 1869, where we explained to you the district court, the civil judge, senior division, junior division, small causes court. But fortunately, the CRPC defines various courts, isn't it? Then the next step will be, I also explained to you what is the jurisdiction of the criminal courts, because you learn what are the courts, what are the powers of the court. Then the jurisdiction. Without jurisdiction, you cannot entertain a case, isn't it? Like under the Code of Civil Procedure, we learned that Section 9 of the Code of Civil Procedure determines the jurisdiction of the civil courts. Then Section 15 to 23 will tell you in which court the suits are required to be filed. Now, similarly, in the CRPC and BNSS, you will find a chapter called Jurisdiction of the Criminal Courts in Inquiry and Trial. Now, that you will find from section 197 to 209 in the BNS, and section 177 to 189 in the CRPC, which I had briefly given to you the provision. Today, I'm not going to elaborately deal with it here, because we have explained that every criminal offense should normally be inquired into in a place where the offense take place, or in a place where the consequences take place. So you please make a note of this section 197 to section 209, that deals with the jurisdiction of the criminal courts. Okay. Then once you have determined the jurisdiction of the criminal court, then the next question which will arise is what are the offenses which are triable by the criminal courts. So we have mentioned there's a high court, there's a court of sessions, there is a judicial magistrate, and the executive magistrate. Now, in the Code of Civil Procedure Code, the civil suits are not defined except a summary suit under Order 37, Rule 1 and 2. Then mortgage suits under Order 37 of the CPC. Section 91, 92 deals with the suits of against a public institution and also public nuisance. Some of these suits are broadly given. But whereas the CRPC, BNSS makes a comprehensive details about how the trials are conducted. Please note, there are trials are 5 types. Number 1, the trial before a court of sessions. That is now dealt in the chapter 19 of the BNSS. Trial before a court of session, commencing from section 248 to 260. Please note that in a BNSS. And in the CRPC...
I'm taking this one, Akhan book.
Are you able to hear? Yeah. So the trial before a court of session take place under chapter 19, commencing from section 248 to section 260. Now, before the court of sessions, and this is equivalent to section 225 to 236 in the CRPC. Now, the normal procedure is that here, the public prosecutor is the person who begins the trial, isn't it? Then opening of the case is done by him. Then the session judge, after the committal proceedings are done by the magistrate, I will explain to you what is the committal proceeding. After collection of the entire evidence by the magistrate, he sends the matter to the court of session, because the court of sessions is not a court of original jurisdiction in the CRPC. Basically, it is the judicial magistrate, which is the court of judicial magistrate. But in some cases, yes, the court of session can directly entertain certain cases, such as defamation against the President of India, defamation against the governors of the state and public servant, and some of the cases are there. The CRPC clearly said that here, the BNSS, it is the judicial magistrates are the courts of original jurisdiction. So some of these court of session take cognizance of cases upon the committal proceedings from the magistrate. So the trial before a court of sessions is, please bear in mind, section 248 to 260, where the session court, after framing of charges, give the opportunity to the parties. Then you have a right to make an application for discharge accused if you find that there is no there is no material to go ahead before the court. It's like a provision under the provisions of CPC Order 7, Rule 11, a rejection of a plaint. So here the accused is given the liberty to make an application for discharge under the provisions of the CRPC and the BNSS, where there is no evidence before the court. Then after a full-fledged hearing is given by the judge. Both the parties lead evidence and rebuttal by the prosecution, and witnesses the evidence of the statements of the accused are recorded. That procedure will take it later on. The second trial in the BNS is trial of warrant cases by magistrate. Trial of warrant cases by magistrate, that you will find in chapter number 20, section 261 to 248. Make a note of it. Now, the equivalent sections in the CRPC are chapter 20, section 238 to 250. So this is a trial of warrant cases by magistrates. What is a warrant case? You should know the definition. So the definitions are given in section 2. What is a warrant case? What is a summons case? I will explain to you in detail when we enter into the definition part. So a warrant trial.
Sir, the first type of trial that you explained was, it was trial by
Court of Sessions.
Court of Session.
Court of Session, that is under section 248 to 260.
260. Thank you.
260. CRPC के अंदर section 225 to 236. Make a note of. BNS के अंदर examination में point of view, they may question, the examiner may ask you a question. If a prosecution, if a charge sheet was filed in the year 2020, under what provisions of law the trial will commence? You will have to bear in mind. Now
225 to 236.
Yes, 225 to 236.
Okay.
Now, that is before a court of sessions, before the court of session. Now, I'd make a mention to you that the court of sessions also directly entertains. Normally, it is not a court of original jurisdiction, but some of the cases which go to the court of sessions are, number one, under the provisions of section 222. Under the provisions of section 222, that is and section 199, prosecution, that you bear in mind. So when I'm taking over the private complaints and the complaint, I will take that part here. Defamation of the governor, defamation of the President of India, Vice President, public servant, they are directly filed in the court of session. Okay. Now we are discussing the next trial of warrant cases by magistrate. There are two parts. Number one, cases instituted on a police report. Police report means after completion of the investigation, the police officer files a report that is called charge sheet, which is not defined in CRPC, but you will find it in a lot of police manuals. that will be under the provisions of section 173. That is a police report. In BNS, the charge sheet is filed under section 193. Please note that after completion of the investigation, because the first information is under the CRPC section 154, under the BNS it is 173. 173 has brought about the concept of a zero FIR and holding of an inquiry which should be done within a period of 14 days. I will explain to you. And the police, after conducting full investigation, he submits the charge sheet, or it's called police report, before the magistrate whether to take cognizance or not. It is well within the powers of the police officer to proceed in the matter, give a suggestion that the case does not disclose much evidence, it is not fit for trial. That is 169 CRPC. And if the case, the evidence is disclosing, then the magistrate proceeds with the matter. So the trial of warrant cases by magistrate is dealt under section 233 to 248 and CRPC के अंदर 238 to 250. Please note that. That is on a cases instituted on a police report. Then item B in the same chapter, cases instituted otherwise than a police report. Otherwise than a police report mean a magistrate may not, mean a police officer may not accept your first information report. Mean the case is not on a police report. Police has refused to take cognizance. Then you are not helpless. You have a right to file a private complaint before the magistrate. That is under the provisions of section 190 CRPC, read with section 200 to 210. Now, under the provisions of the new BNSS, it is section 210 to 223. Please note that, where the magistrate can take cognizance complaint cases. On complaint cases, the magistrate can take cognizance. A complaint can be from the magistrate himself. A complaint can be by a police officer, where a police officer cannot register first information report because the offense is not cognizable. A police officer can register FIR only in respect of offenses which are cognizable, mean where a police officer can arrest without a warrant. Whereas in cases non-cognizable, small offenses, marpeet ke cases, your neighbor is troubling you, causing you nuisance, so they become non-cognizable offenses. So the police officer has no power to investigate. But he has to take the permission of the magistrate to investigate. Upon such a permission being given, he has a right to file a complaint. Then in that cases, the police officer will become a complainant. So it will be a complaint case under the provisions of section 267, which is triable by the magistrate. So this is the provisions relating to cases otherwise than a police report. You will find in the BNS section 267 से लेकर 267 to 270. Okay. Yes. Then, sorry, 273. Okay. Please, 273 BNSS. That is equal to section 244 to 250 of the CRPC. Now the next trial, the fourth trial in the CRPC envisages is trial of summons cases by magistrate. It's very important. Now this you will find from section 274 to section 282 in the BNS And in the CRPC, in chapter 20, section 251 to 258. Now, trial of summon cases in the earlier CRPC, magistrate had no power to discharge the accused. Whereas in the present in the BNS, there is a proviso to section 274 which says that if the magistrate considers the accusation to be groundless, he shall record the reasons in writing, and the accused shall be released and shall have the effect of a discharge. A defamation case is filed by you against your friend, against your neighbor, against anyone. Normally, under the old CRPC, magistrate had no power to discharge. Now, what was the remedy? People used to go to the High Court under Section 482 CRPC in inherent power. Now, in summons cases, you need not go to the High Court for discharge. You can go the magistrate itself. This is one of the laudable invention in the new CRPC or BNS, you may call it here. But whereas under the provisions of the old CRPC, there was a power of discharge which was given to the Court of Sessions under Section 227. Similarly, the magistrate in warrant cases had a power of discharge under Section 236 and 245. Now, presently also that power is available in session trial and warrant cases, as well as a trial before a magistrate in warrant cases, both on police report as well as in a report in summon cases which have been filed by in a warrant cases. Now, in the summary trial, in a summon cases, such a power was not available for discharge earlier, now which has now been inserted by virtue of the proviso to section 274, which you may note down. Okay, this is the new provision under section 274. Now, the last trial before in the CRPC is a summary trial, which you will find from section 283 to section 288. Okay, this you will find in the analogous provision in the CRPC or section 262 265. Now that is but whereas in the case of a summary trial, there is no provision to discharge. Okay, please note that if you want to, but there's a provision for stopping the proceeding. If the proceedings are not commenced within a period of 6 months' time, you can move the magistrate to stop the proceeding. And if you are aggrieved, you can go to the High Court for quashing under the provisions of inherent powers. Or you may go to the Court of Sessions by virtue of his revisional powers. That is not a power. So these are the 5 provisions relating to the summons trial, the trial such as a sessions trial, warrant trial before a magistrate in cases on police report, warrant trial in otherwise than cases than filed in police report. Then we learned right now, trial in cases of summons cases, trial in cases of summary cases. Please note that these are the CRPC, the Bharatiya Nagrik Suraksha takes care to define the various trial, which you will not find in the Code of Civil Procedure. Civil procedure, there are very basic trials I mentioned. Civil is the summary trials, these summary cases under Order 7, Rule 1 and 2 CPC. Then 91, 92 cases, I'll explain to you what the cases, very briefly it's mentioned. But whereas CRPC takes care to define all these cases. Now the next step will be before the criminal court. So you learn the composition of the court, power of the courts, isn't it? Now the jurisdiction of the criminal courts and what are the various trials. Now a criminal law is set into motion by lodging a first information report. Okay, please note that. Like we learned here earlier, a civil law is set into motion by presentation of a document called plaint, but here the criminal prosecution commences with the presentation of a first information report under the CRPC section 154, now under the new BNS 173. If the police officer does not take, because this is only in cognizable cases. Now, what is a cognizable case? The definitions which are given in the CRPC are very important, which I would like to tell you. What is a complaint case? What is a cognizable case? You please bear in mind the provisions of section 2H defines complaint. Complaint can be writing के अंदर, it can be orally. There is no mandatory requirement, it must be in writing. Section 2H. Then, mind you that investigation is normally done under the CRPC, under the criminal code, only by magistrate, only by the police officers and not by magistrate. Police officers or any other person who may be appointed by the magistrate. Whereas inquiries are conducted only by the magistrate, that is section 2K of the BNS will makes you. Inquiry means every inquiry other than a trial conducted under this Saitya by the magistrate or court. Police officer cannot conduct any inquiries. Private persons cannot conduct inquiry. The jurisdiction is only vested with the magistrate or the criminal courts. Please note that. Now, another important, some of the definitions which you should know that here, what is a cognizable or non-cognizable offense? Now, cognizable offense definition you will find in section 2, small g. See that I would like to bring your attention to cognizable offense mean an offense for which cognizable case mean a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. He doesn't need to go to the magistrate taking permission to arrest if the offense is serious. If it's a murder case, if it's a robbery case, if it is a rape case, he doesn't need. So this is the case. Please note that the definition of a cognizable offense is a 2G of the case. Then a non-cognizable offenses is important here because under the scheme of the CRPC, the police officer can only investigate or register the FIR under section 173 BNS or 154 CRPC only if the offense is cognizable. Otherwise, no. Now, what is a non-cognizable case? Would like to bring your attention. Clause number 2O. O original. See, the non-cognizable offense mean an offense for which a non-cognizable case a police officer has no authority to arrest or without warrant. So under this clause, the magistrate, the police officer cannot investigate. He needs the permission of the magistrate. That is the definition of a cognizable offense, non-cognizable offense. Then the CRPC, some of the definition which you should know, what is a bailable offense and non-bailable offense. Please note that. Now, bailable offenses. Bailable offenses, the bail bonds have been defined in section section 2B defines bail means a release of a person accused, suspected of commission of an offense from the custody of law on a condition imposed by the court. So that bail is granted by the court or even by the police magistrate in the matter. So definition which are given under the court especially of bailable, cognizable or non-cognizable, are required to be maintained. Now, when you lodge a complaint to the magistrate, when you lodge a complaint, sorry, to the first information to the police officer, the where I mentioned to you, a criminal law is set into motion by the filing of a document called the first information report, which you will find under section 173. 173 खोलेंगे आप, मालूम पड़ेगा आपको. Yes. Got it? Section 173. You have a Bear Act with you? Yes. Now, section 173 is equivalent to section 154 CRPC. Now, the salient features of this section are now that a zero FIR can be filed. Zero mean you can be in Bombay, you can record the FIR in Delhi, Madras, you can any part of India. There is no bar. It starts with a section called every information relating to the commission of a cognizable offense, irrespective of the area where the offense is committed, may be given orally or by electronic communication. Orally or by electronic communication. Now, if it is given orally, then you are required to come and sign it before the officer within a period of 3 days' time. Because they require your signature. Under the provisions of 154 CRPC, it was a mandatory requirement that the FIR should be signed by you, should be in writing. Now here orally it can be done. And electronically dispatched, suppose you have sent an email from Delhi that robbery has taken place at your house in Mumbai. The Delhi officer, SHO, dispatched the FIR to Mumbai office. And you also sent an email. Then the law requires that within 3 days you must come and personally sign it here. Now, what is the new requirement here? Subsection 3 is added here, which says that where the offense is punishable between 3 years and 7 years, the police officer who received the first information report is required to hold preliminary inquiry. Because you are not supposed to arrest any Tom, Dick and Harry. Unreasonable arrest must be avoided. In matrimonial offenses, they used to arrest not only husband, but the entire family, father-in-law, mother-in-law, sister-in-law. Now that became a subject matter of dispute before the Supreme Court in Arnesh Kumar's case. Isn't it? Arnesh Kumar versus State of Bihar is the leading judgment on that point. Now the court said that without giving notice, prior notice in matrimonial offenses, arrest should be avoided. Why are you arresting the father-in-law, mother-in-law, son-in-law? Not necessary. These are matrimonial offenses. Now, even in civil transaction, commercial transaction, arrests are sought to be done. The Supreme Court in several cases criticized this action on the part of the police officer. So the police officer is given the discretion not to arrest. He must hold preliminary inquiry. If at all any arrest is required to be done, only with the permission of a deputy superintendent of police who is in the position of a executive magistrate. Isn't it? He will apply his mind. This is in conformity with the judgment of the Supreme Court in Lalita Kumari versus State of UP, a constitution bench judgment, where they laid down the criteria in what offenses the police officer can arrest, what offenses he should avoid, in what offenses he must hold inquiry. So if you go to the judgment of the Supreme Court in a constitution bench judgment of 5 bench judges in Lalita Kumari versus State of UP, you come to know this here. So these are the guidelines which have been incorporated here under section 173. Now, if the police officer has refused to take your FIR for A reason, B reason, you are not helpless. The law mandates that here, the complainant can approach the superintendent of police, whose position is that of an executive magistrate, to look into it. Why the first information report has not been taken cognizance of? Now, even suppose, assuming for the sake of argument, even your deputy has given not taken interest in the matter in filing the complaint. You wanted an investigation by the police officer under section 156(3), now which is under the provisions of section 170, 176(3) it is now, isn't it? 174(3) of the BNS. So when the police officer, sorry, internet issues, when the police officer has not taken your FIR, then you have a remedy to go before the superintendent of police under section 174. Even if the superintendent of police does not take it, you have a right to directly approach the magistrate under section 190. And take out an application under 156(3) under the CRPC. Now it is section 174 subclause 3 of the BNSS. Now the requirement which you are required to follow are: number one, file an affidavit placing on record that the offense which is committed is a cognizable offense. It may be robbery, it may be theft, it may be cheating, it may be breach of trust, which are cognizable offenses punishable for more than 3 years. The police officer has refused to take cognizance. The superintendent of police also did not bother to look into it. Then you filed a complaint to the magistrate and invoke his powers under section 174(3), 173(4), which said that no, and a police officer receiving the order may exercise the same powers in respect of investigation, except power of arrest, as an officer in charge of a police station, cognizable offense. The Supreme Court in Priyanka Srivastava's case versus State of UP stated that the requirements are: number one, file the affidavit placing on record that the police officer has refused to take cognizance. You exercise the option going to the superintendent of police. They have not done it. The learned magistrate may direct the police officer to conduct investigation. Okay, that is a remedy which will be available to you. Now, upon no sooner the police officer receives the first information report, then the next step will be powers relating to arrest. Now, earlier it is section 41 of the CRPC. Now, in the BNSS, section 35 onwards. Arrest of a person, chapter 5. Chapter 5 in the BNS, and under the provisions of CRPC commencing from section 41 onwards in respect of offences which have been committed prior to 2023, that you will find under the provisions of chapter number 41, you will find it under the provisions of chapter number 5 CRPC. Now all of you know that investigation, once a person is arrested, police officer has very wide powers under section 41 CRPC. Now it is section 35 of the BNS, particularly in respect of a cognizable offences. Now the law is that now police officer, in respect of offences which are punishable up to 7 years, a police officer is required to serve a notice under section 41A of the CRPC. Now it is section 35 subclause 3 of the BNS. Without giving this notice, yes, if the offense is punishable more than 7 years, murder case, rape case, such a notice can be dispensed with. But these are offenses punishable between 3 years and up to 7 years. It is mandatory to give section 41A notice. Now, the moment 41A notice is given, normally as a lawyer, what will you do? You will advise your client, go to the court of sessions or high court, obtain a anticipatory bail. Isn't it? Bail powers are anticipatory bail, section 438 CRPC. Isn't it? 438 CRPC with the court of sessions and the high court. The judicial magistrates do not have power to grant anticipatory bail. Now, the magistrates and the police officers have power to grant regular bail. Now, all of you know that here, a person who is arrested cannot be detained by a police officer for more than 24 hours. This is the mandate of section 57 and 58 BNS and CRPC, and also article 22 of the Constitution of India. 24 hours ke baad, next is the police officer is required to produce the accused person, arrested person, before the magistrate. That procedure is called remand procedure. Please note that this is a very important. Arrest ho gaya abhi, because the first information is filed under 173, arrest is done under 35, and remand powers where a police inquiry, where remand powers will start from section 187 in the BNS and 167 in the CRPC. The sections are not correctly arranged, so you will be confused as a young lawyer or a student of law. So criminal law is set into motion under 154 CRPC, 173 BNS. That is the starting point. Arrest is taking place under 41 CRPC and 35 of the BNS. Remand is under section 167 CRPC and it is 187 of the BNS. Now the remand is done within 20, when the investigations are not completed. The police officer is required to produce his case diary. Please note that under the provisions of section 172 CRPC, a police officer maintains a case diary. He must write down in the case diary when did he receive information relating to the commission of the offense and what steps did he take. Did he record the statement of any persons? Did he conduct any spot panchanama? Did he do any identification parade of the witnesses or the accused person? So these are all steps to be taken by the police officer, which he must record and present it before the magistrate in a proceeding called remand procedure. Remand is not an empty formality. Please note that. At the stage of the remand, police officer has a right to ask the magistrate, I could not complete the investigation in 24 hours as per the mandate of Section 57 and Article 22 of the Constitution of India. And it's a heinous crime involving conspiracy. Several accused are required to be arrested, and many articles are required to be taken custody of. I had to do thorough investigation. So the Honorable Court may kindly grant me remand of 15 days period. That is called police custody, PC. Grant me PC. The magistrate cannot grant at this stage custody for more than 15 days. Police officer may ask 15 days, magistrate may give 1 or 2 days. But if the magistrate is of the opinion that police custody is not necessary, I will remand him to judicial custody or a magisterial custody. That is one of the options available to the magistrate. Now, this custody matter, whether judicial custody, magisterial custody, does not debar the accused. You are a defense lawyer to make an application for bail. You may take up the plea that, my lord, the offenses which are committed by the accused person, he has been falsely implicated. He is available for investigation. He will not run away anywhere. He has firm roots in society. There is no point in violating my life and liberty under Article 21 of the Constitution of India. My fundamental rights are violated. I have a family and children who need me. I have a job. If I am arrested, kept in custody, I will not be able to support my family. At the same time, I will make myself available for investigation, but release me on bail. Please note that you should press this. You must press you press the provision for bail before the magistrate. There is no bar here. The magistrate has the discretion after perusing the case diary of the police officer. Number one, whether to grant the police officer magisterial, the police custody. If he had decided to grant police custody, he cannot grant for more than 15 days at a stretch. Now, under the new CRPC, under BNS, he has been given the liberty to grant, periodical custody from 40 days to 60 days. In a maximum, the custody of the accused person cannot exceed more than 90 days and 60 days. 90 days in cases of heinous crime like death punishment, life imprisonment. 60 days in other offenses. So in cases which are punishable with death, life imprisonment, the magistrate can grant custody up to 60 days. In other cases, he can grant custody up to 40 days. But the law mandates that in one stroke, the custody of the accused person cannot exceed at one time more than 15 days. But for reasons to be recorded, the new CRPC, the BNS is giving wide power to the magistrate, unlike the old CRPC. Under the old CRPC, the remand procedure cannot exceed more than 15 days each remand. Now here the police officer, after 15 days period, the accused must be released on bail. That was the law. I will, when I'm dealing with more about the remand, I will give some of the judgments of the Supreme Court when we take the next lecture. I think I'm told the time is up. We'll stop today. And if you have any queries, please ask me. In the next lecture, we'll go further into details about the remand, the arrest. I will cover the bail, the bail to be granted by the police officer in bailable offences, bail to be granted by magistrate in non-bailable offences, the anticipatory bail which can be granted by the Court of Sessions and the High Court, and cancellation of the bail. So that is will be next topic. Anybody has
Yes,
any
sir.
so far? Please ask
Yes,
me.
sir.
Yes.
Hello, sir. Namaste. Sir, I have
Yeah,
a question. Sir, in complaint cases under Section 223, if magistrate wants to allow for further inquiry, will he allow in Section 225, sir, or in under Section 175(3) of
It's a
BNSS?
private complaint.
Yes, sir. If he wants to allow for further inquiry, will be giving further inquiry under Section 175(3), sir, or under Section
Inquiry is
225?
to be, if inquiry is to be ordered only to the magistrate.
Yes, sir.
Investigation to the police officer, inquiry is to the magistrate. You read the provisions of provided the magistrate make over the case to another magistrate, the proviso to Section 223 Padya. Inquiries are only to magistrate. Police officer cannot do inquiries.
So for police officers, sir, to investigate, to further investigate.
Yes, further investigation will be coming under the old 173 subclause 8. Here 170, here under the new provisions, under the new provision 173(8) can there the magistrate, the police officer can apply for permission to the magistrate to further investigate. There is no bar.
Thank you, sir.
Further investigation is permissible, provided some new evidence is come on record, or investigation was not done correctly before the court.
Okay, thank you, sir.
Yeah. Anybody else has any question?
Nobody.
Hmm?
Nobody, it seems.
Nobody? How many people are joined today? Okay, we'll stop today here because it's a festival season. All of you can go and enjoy and take the darshan of Lord Ganesha. Okay, all the best. Next lecture will announce when I'll be taking CPC within a week, within 4 or 5 days time. In a week, either one lecture will be CPC, another CRPC. Okay.
Sir, anything we should study for that 4-5 days?
4 or 5 days you study.
We'll inform them.
I will inform you accordingly, and I will take the next lecture in CPC, which are the courts where how you have to file the complaint, registration of a plaint, which court, what kind of cases go to various courts. No? So there is a high court which entertains civil cases. There is a city civil court entertaining cases, court of small causes court. I will give the classification of each court. Then the civil judge senior division, division, then money cases, property cases, suit for specific performance, summary suits, then mortgage suits, how they are filed and where they are filed. I'll explain to you in the next lecture.